Dear students, hello and welcome to this video lecture series on behalf of CLAT SATHEE. I am Dr. Animesh and today we are going to continue our discussion on matrimonial laws. And the topic for today is one of the most interesting topic that there is, and that is laws related to maintenance. Now, more often than not, it comes in the news that this much alimony has been paid in a marriage, or every time a domestic dispute arises, the first thing that has to be determined, first thing that has to be understood is about maintenance. This is a very, very important aspect. Multiple disputes are there, and it has always been in news. If you'll just open the newspaper, you will find some or the other report about the maintenance of it has been given or is demanded by one of the parties. So, without any delay, let's begin. Obviously, the maintenance, just like all the matrimonial laws, are based on the religion of a person. Now, religion matters, so that is why we have to understand it from the sense of Hindu law, Muslim law. But maintenance is also provided under secular law, that is, under the laws which are applicable to everyone. So, as the first leg of this particular video, with this video lecture, we'll understand what maintenance means. Then we'll understand how under Hindu law maintenance is understood, to whom it is given, how it works. We'll also discuss it under Muslim law, and finally we'll discuss how under secular law it works. Okay, so without any delay, let's move to understanding maintenance. Now, maintenance is something that is given by one person to another on the basis of their status. This is very important to understand. People do things or people take care of other people because sometimes they're obligated by contract or trust or something like that. But here, for the purpose of maintenance, your status is most important, not a person's conduct. Generally, people deserve something because of their conduct. आप जैसा करते हैं वैसा आपको मिलता है. But maintenance is something that is purely dependent on the status of a person. Like, suppose if you have a child, if you are a mother or a father, now you have an obligation to maintain that child. That's it. Even the moment a child is born, there is not only a moral obligation to take care of that child, but it's a legal obligation. You cannot simply say that I do not want this child, I do not want to maintain this child, and I'll have nothing to do with this child. No. Law obligates that you will have to take care of that child. You will have to provide for that child. Every need, food, shelter, education, care, everything that you will have to give. If you abandon your child, that's a crime. So that child has done nothing for you. And it is uncertain whether you will be benefited by that child in the future or not. But nonetheless, by the status of being a father or mother, you are obligated to maintain your child. As simple as that. You are obligated to maintain your child because you are the father or the mother. Same goes with if a person has a wife, whether you have cordial relationship with your wife or you are fighting with your wife, notwithstanding anything, you are supposed to maintain your spouse because of that status of a spouse. Suppose marriage happens, you might not have seen your wife or wife, but still a wife has a right to take maintenance from the husband. Husband has an obligation to pay maintenance to take care of the wife. This is very important to understand. Similarly, parents. So the purpose of maintenance is to provide, to take care of the person who is dependent on the other. Now you'll have to pay the maintenance to your dependent, and that maintenance, there is a very interesting logic to the maintenance. Maintenance has a logic of parity. In India, in Bharat, whenever you are maintaining someone, you do not have you are not only obligated to give necessities to them, yani ki you have to ensure animalistic survival. No, there is a concept of parity. Parity means if you have an obligation to maintain someone, you will maintain them in the same way that you are maintaining yourself. Meaning thereby that if I am if I'm crorepati, I'm a millionaire, I'm a billionaire. Now, suppose I have to maintain my parents, my wife, my children. I will not give them 10,000, 20,000 rupees to maintain themselves. Although a person can maintain themselves in that much money, but still, if I'm a billionaire, I'll have to pay millions in maintenance, because the person who is seeking maintenance from me is a close relative, is a dependent, and thus he is also entitled to keep the same standard of living as me. So that's why you see in multiple cases 300 crore alimony is given. Obviously, if that man has 1,000 crore rupees assets or property, he will have to give alimony on that basis, maintenance and alimony. So that is how it works. The logic of parity is always there. That if you are maintaining someone, you have to maintain them in the same way you are maintaining yourself. You cannot say ki sir, a person can maintain themselves in 5,000. Even though I'm earning 50 lakh, I'll give 5,000 to my wife or my parents or my children. That's not how it works. So maintenance is based on the logic of parity. It is the logic of maintenance to prevent destitution. The people are dependent on their families. If they are dependent, they are entitled to get maintenance. So the logic of dependence, preventing or protecting people from destitution, वो बिल्कुल भिखारी ना हो जाएं, सड़क पर पे ना आ जाएं, they should not endanger themselves, or they should not be exploited. All these reasons are there, due to which the law of maintenance is there. That see, nobody should be exploited, nobody should be harassed, nobody should be left on street. So the people who are in a position to maintain, they are obligated to maintain. This is very important to understand. Okay, now who are the people entitled to claim maintenance? Generally there are two classes of people who are entitled to maintenance. First is the relatives. Obviously it includes your children, parents, and spouse, wife primarily. Except under Hindu Marriage Act, under no circumstance a husband is entitled to maintenance from the wife, but generally wife is always entitled to claim maintenance from the husband. So we have children, we have parents, and we have spouse. Those are the people who are entitled to claim maintenance. But children means only minor children. Although the personal laws allow maintenance to be given to a daughter till she is married, for the son it is 18. If a son has reached the age of 18 years, the parents are absolutely not obligated to maintain that child. If you are above 18, your parents can simply throw you to the streets, and they can say that we do not want to pay a single penny to this boy. If you are above 18, you are supposed to look for yourself. That is the law. But daughter, they have the right to get maintained till the marriage. Unmarried daughter is entitled to maintenance. Similarly, spouse is entitled to maintenance. Parents and spouse both, if they are incapable of maintaining themselves, they are entitled to maintenance. See, the maintenance is always given if the person is unable to maintain themselves by their own income and property. If the other person is earning very well, they are capable of maintaining themselves, and are in the position to sustain a lifestyle. In that case, they are not obligated. They do not have any right to get maintained. Suppose if I have a lot of money and I am maintaining myself, I cannot file a case for maintenance against my son, because I am capable of maintaining myself. So that is something. The people who are entitled to claim maintenance become entitled if they are unable to maintain themselves. Second is the obligation based on property. Likewise, if somebody gives you a property and also an obligation to maintain them or anyone else, in that case you are also obligated to maintain that person. To give you a simple example, suppose a person gave a piece of land to someone, to a friend, and said, "Kisi, I am gifting you this piece of land, 100 acres. I am unable to manage this, but in lieu of that, you will maintain me till I die." Now, in this case, the person who takes the land also takes the obligation to maintain, that person. You are obligated by that contract of maintaining, but obviously you will have to maintain uh, to the value of the property. If the maintenance goes above the value of the property, there is no obligation to maintain. So obligation is attached to the property. There is a very famous story by Munshi Premchandji, who is a stalwart of Hindi literature, a very famous person. He has a story called Panch Parmeshwar from his collection of stories called Mansarovar. In Panch Parmeshwar, there is a old elderly woman, and she gives a piece of land to her nephew, and nephew agreed that okay, I'll provide maintenance to you, roti kapda uh, to you till you die, and then later he refuses to maintain her properly. So in that case also, in law also, that is considered improper, and the person can be legally bound to maintain. Third type of maintenance is based again on the inheritance of property. Suppose I inherit property of someone, then I also inherit the obligation to maintain the people that he had the obligation to maintain. Now this is very important and interesting. Suppose I inherit property, a person, my friend who had a wife and had a children, or suppose he had a wife with whom he was estranged. This is a very simple example. My friend was estranged with his wife. They had dispute, and while he was alive, he was maintaining his wife because the law compels him. But when he fell ill, he wrote a will, and he gave the property to me, his friend. An entire property he made a will in favor of me. Now, if I inherit his property of that dead person, I also inherit the obligation to maintain that was attached to the person who was deceased. यानी मेरे मित्र को मेंटेन करना पड़ता उसकी वाइफ को, तो उसकी प्रॉपर्टी मैंने इनहेरिट की है, तो अब मुझे भी अब उसकी वाइफ को मेंटेन करना पड़ेगा, बट ऑब्वियसली फ्रॉम दैट प्रॉपर्टी ओनली. Once the property is extinguished, there is no obligation to maintain. So the person who are entitled to maintenance कौन हो गए? Those who are related to you, like children, like parents, and like your spouse. Acha, you do not have an obligation to maintain your siblings. That's a common misconception. You are not obligated to maintain your siblings. Siblings are supposed to maintain themselves. So you have an obligation to maintain your children, your wife, and your parents, and that is very personal obligation is there. Personal obligation means that you have to maintain them. You cannot say, I do not have money to maintain. It's not that you should be rich to maintain. The court will say, beg, borrow, or steal. But if you have a wife, if you have children, if you have parents who are dependent on you, then you have to provide for them. It's non-optional. It's non-negotiable. You have to maintain them. Beg, borrow, or steal, your property will be utilized. You can even be sent to prison if you fail to maintain them. So this is very important to understand. Civil prison, obviously, but nonetheless, you will be sent to prison, civil prison, if you fail to maintain your parents or your wife or your children. So the people who are these people are considered as personal obligation, and this is true across all the laws, Hindu law, Muslim law. In all the laws, the provision is same. And then there is an obligation based on property. If somebody has given you property or you have inherited property, then in that case you also um, inherit or you get the obligation to maintain from that property. If you have the property sufficient to maintain them, then you will have to maintain. If the property is less, the obligation is more, then you do not have to maintain. Okay. Then statutes. There are multiple statutes under Hindu law. There are two primary statutes that we'll discuss. Then under Muslim law, we have some laws, and then we have secular laws that will discuss various statutes that are there. Okay. Now, maintenance under Hindu law. Now, under Hindu Marriage Act of 1955, there is an obligation on the spouse to maintain the other spouse. This is very important to understand. That a husband or a wife can claim maintenance or even permanent alimony from their spouse. Under Hindu Marriage Act, at the time of dissolution of a marriage or at the time of matrimonial dispute, the husband or wife, either party to the marriage, and this is the only law where it is gender neutral. In other law, wife claim maintenance from the husband, husband cannot claim maintenance from the wife. So, under Hindu Marriage Act, the husband can claim maintenance from the wife, and also wife can claim maintenance from the husband. Now, what's the difference between maintenance and alimony? The difference is simple. Maintenance is periodical, alimony is one time, lump sum payment. If the parties agree that I will, that the money, this much money will be paid, but one time payment. After that, there is no repetitive payment. So that is called alimony, while permanent alimony, while the maintenance is a periodical payment. It can be given quarterly, it can be given monthly, it can be given yearly as the court decides. So this much information is very required. But to be very honest, the husband is the husband never gets the maintenance from the wife unless in the case of physical or mental disability, unless he is incapable of earning. So if the husband is disabled physically or mentally, then in those cases, the courts have been known to provide maintenance to the husband as well. But generally, wife can claim and get the maintenance from the husband or alimony from the husband. Uh, and while deciding maintenance and alimony, the income and asset of both the parties are taken into account. Whose fault, their conduct, what's the lifestyle, all of those things are considered by the court, and then the court arrives at the amount which has to be paid. Now, if the wife is earning, she has money, or she's earning, in those cases, the generally maintenance is refused. But if the wife is not earning, though she is capable of earning, still she is entitled to claim maintenance. Now, this is very important. Like if I say that my wife earns 1 lakh rupees per month, in that case, the court will say, okay, here the husband, yani ki me, I am not obligated to maintain my wife. But at the same time, 1 lakh rupees my wife earning, I am earning also 1 lakh rupees, 1.5 lakh rupees. The court say no. There is no substantial difference between the income of the parties. The wife is earning enough to maintain the same lifestyle as the husband. So in that case, the husband do not have an obligation to maintain his wife. But suppose my wife can earn. She's a highly educated woman. She's capable of earning, but she chooses not to earn any money. Then whether the question is whether she's entitled to maintenance, the answer is yes. The overwhelming majority of judgment suggest that even if a wife is capable of earning, see, everybody is capable of earning some money. But if even if my wife is a doctor or a very skilled person, highly qualified, but she chooses not to earn, in that cases, she cannot be compelled to earn. Yani ki the law will not say, ki, okay, you are not getting maintenance from your husband, you should earn and then survive. That will not, the law will not say that. If she is not earning, the husband is obligated to maintain. Similarly, if there is a huge difference between the income of the parties, like I am earning 10 lakh rupees, but my wife is earning 50,000, and she will not be able to um, maintain the same lifestyle as she had with me if the divorce or any degree of dissolution happens. This alimony or permanent maintenance is given only in the case where marriage is dissolved. Marriage खत्म होती है तो मिलता है maintenance. तो अब marriage खत्म हो रही है, तो obviously I am earning 10 lakh rupees, my wife is earning 50,000, so she will not be able to maintain or the same lifestyle that she was maintaining with me. So in that case, court can still grant her alimony from me or maintenance from me, so that she'll be able to maintain the same lifestyle as she has been accustomed to, or that she was entitled when she was with me. So all these things, the court decides the maintenance, or the parties can also themselves agree on the amount of maintenance. But it is generally discussion of the court, and the court keeps all that circumstance, how much assets are there, what is the income of the parties, whose fault it was in that matrimonial dispute, what are the rights and duties and obligation of the parties, whether there is a health concern, whether there are children, whether the husband has some other obligation like aged parents, or so all these things are there. I recently read a very wholesome moment was created when the husband failed to pay maintenance to the wife. So wife approached the court, and in the court she found out that the husband is suffering from cancer. So not only the wife withdraw the case, but also paid money to help in the treatment. So this is a very wholesome moment happened recently in Madhya Pradesh, some years back. It happened. Okay, so a simple example is that the wife is entitled to maintenance from the husband under Hindu Marriage Act. Similarly, under Adoption and Maintenance Act, the parents, the children, and the wife, all three of them are entitled to maintenance. Here, the wife is entitled to maintenance. It should be a valid, legitimate marriage to claim maintenance. And here, the wife is also have to prove that if she is living apart from the husband, what's the reason behind living apart? If the wife can provide a proper reason why she is living apart from the husband, in that case, she is entitled to maintenance and she can claim maintenance under Hindu Adoption and Maintenance Act. Similarly, parents and children are entitled to claim maintenance, and this Hindu Adoption and Maintenance Act also has that logic of dependence. Dependence in the sense that if I inherit someone's property and that person has dependents, then I will have to maintain those dependents from the money that I've inherited from a dead person. That is also provided under Hindu Adoption and Maintenance Act. Then we have maintenance by a joint Hindu family. Now, under Hindu law, there is a concept of joint Hindu family. Generally, people have ancestral property in which the joint families live together, and the eldest member is called Karta. Now, Karta is an under obligation to maintain every member of the joint Hindu family. If I'm a part of a joint Hindu family, I'm a member of a joint Hindu family, I am entitled to claim maintenance from Karta. I'll go to Karta and say, sir, please pay me some money. I cannot maintain myself. So the Karta is under an obligation to pay maintenance to everyone. Although he's not an obligation to pay everyone equally, but nonetheless, he is duty bound to maintain me from the assets or revenue of the joint Hindu family. This concept you will learn in your law school. It's a complicated and a vast concept, but nonetheless, under joint Hindu family also, the provision of maintenance is there, and all the members of the joint Hindu family can claim or can have a right to be maintained from assets of that joint Hindu family, income or revenue of that joint Hindu family. Moving on, under Muslim law, see, there is something called nafaka or nafka. Every wife is entitled to claim maintenance from her husband. Similarly, a Muslim has a obligation to maintain his parents or children. But see, interestingly, under Muslim law, the husband or the man has an obligation to maintain his children, wife, or parents only if he is capable of doing so. Contrasting it with Hindu law or to some extent secular law as well, there is no concept of beg, borrow, or steal. If you do not have money, then you are not obligated to maintain your children. Only if you have money, then you are obligated to maintain your wife. And also, there is the concept of parity is very weak. You do not have to provide for your wife as much as you are the same life standard as you are living. But in Indian law, if we follow secular law or the secular principle. So under Muslim law also, a man is obligated to maintain his parents, children, and spouse. And the question of maintenance to Muslim wife became very interesting. And here the term Muslim wife does not include divorced wife. See, under Hindu law, I'll clarify, a person is obligated to maintain divorced wife as well. That's why I stated that if a divorce happens, in that case, maintenance or alimony has to be fixed by the court. How much money the husband will give to the wife. But under Muslim law, the husband is not obligated to maintain his wife beyond the iddat period. Iddat period is the 3 months during which the wife cannot remarry. So during that iddat period, the wife is maintained by the husband. After that, the husband has no obligation to maintain the wife after divorce, and it is also considered immoral in some contexts. So The legendary case, yes, maintenance to a divorced wife. Acha, also we discussed in the last class that a Muslim husband can divorce his wife at any point of time. There is no reason or there is no remedy to the wife after she has been divorced. She cannot go to the court and say that my husband was unjustified in divorcing me. No, that's not the case. The Muslim woman can be divorced by her husband at any point of time. So this became a point of contention. Divorced wife, the right of a divorced wife became a very crucial issue. See, Muhammad Ahmad Khan versus Shahbano Begum is one of the cases which has changed the Indian politics and legal history. This is a case which is as important as the cases may get. Now, on Justice Y.V. Chandrachud, the father of the former Chief Justice, and he was also, I believe, a Chief Justice, Y.V. Chandrachud, in the case of Muhammad Ahmad Khan versus Shahbano Begum, stated that although Muslim law prohibits or Muslim law states that a divorced Muslim woman is not entitled to claim maintenance from her husband, secular law, that is CrPC at that point of time, 125 CrPC, a Muslim woman is entitled to claim maintenance from the husband. So effectively, Rajiv Gandhi was prime minister at that time. Supreme Court gave supremacy to the secular legislation. Now, under Code of Criminal Procedure, maintenance is provided to the wife, and in that case, wife includes divorced wife. So this Muhammad Ahmad Khan, who was a advocate probably in Bhopal, he divorced his wife, Shabano Begum, who was an elderly lady, 60, 65 she was. And she was divorced, and simply she went to the court and said, Kisi, I want maintenance. And she was given some 179 rupees as maintenance. It's an old case, 1970s. 179 rupees she was given as maintenance. The Muhammad Ahmad Khan, he said that no, I will not give maintenance to my wife because my religion says that a husband is not obligated to maintain his wife post 3 month iddat period. So if my religion says I do not have to maintain, I will not maintain. Supreme Court stated no, that no, we are a secular country and the secular law provides that you will have to maintain, so you will have to maintain. So after this, there is a huge dispute. All India Muslim Personal Law Board, they started protesting, and eventually they pressurized the government to enact Muslim Women Protection of Rights on Divorce Act of 1986. Now this judgment had an effect of overturning the judgment of Muhammad Ahmad Khan for Shahbano Begum. This judgment provided this legislation provided, this act provided that a Muslim woman who is divorced is entitled to her meher. The law will ensure that she gets meher. She is entitled to get maintenance during iddat period, obviously. And if has children, the children will maintain her. If there are no children, then those people who will inherit her property will maintain her. Still, if no one is there, then Waqf board will maintain her. The Waqf property, see, Waqf is a very rich institution, a lot of property and revenue. So the Waqf board will provide her maintenance. But the husband, after the dissolution of marriage, was not given an obligation to maintain his wife. So Muhammad Ahmad Khan's Shahbano Begum was effectually overturned. But यहाँ पे केस मैटर खत्म नहीं होता. The judgment came of Daniel Latifi. In case of Daniel Latifi, this is a very interesting case, Daniel Latifi case. In Daniel Latifi case, the question was whether this act is valid or not, because it simply takes away the right of a Muslim woman, divorced Muslim woman, to claim maintenance from her husband, while the same right is available with a Hindu woman. So in this case, the Daniel Latifi case, the Supreme Court was asked to consider, sir, this is discriminatory, violation of Article 14. A Hindu woman will get maintenance, but a Muslim woman will not get maintenance from her husband just because she is a Muslim. So this is problematic. Now, the Supreme Court, in Daniel Latifi case, gave a very interesting notion. It said, ki, see, the act says that the husband will have to provide maintenance or make provisions for her maintenance during iddat period. Now, during iddat period, the husband will have to pay that much money to his wife that will allow her to survive even beyond iddat period. यानी कि 3 महीने के अंदर ही a Muslim husband is obligated to pay that much money to his wife so that she will be able to survive even beyond that period. Now, this was the interpretation taken by the Supreme Court, and it effectually made it compulsory for the husband to provide alimony. Alimony क्या होता है? One time lump sum payment which will allow the other person, the wife, to survive till she is remarries or till she is dead. So that case, Supreme Court interpreted this act in such a way that the right of the Muslim woman was protected. And eventually, after a period of time, the recent judgments, they have stated that no, the wife is entitled to claim maintenance. A Muslim woman, although she is not entitled to maintenance under Muslim law, divorced Muslim woman, but she is nonetheless entitled to claim maintenance under secular law. Secular law provides that the maintenance has to be provided even to a Muslim woman who is divorced by her husband. Now, this is a major reform that has been made. Earlier, the Muslim woman, strictly under Muslim law, she was not entitled to maintenance once she has been divorced, but under secular law, she can claim maintenance. And that is the correct and current position of law, unlikely to be changed. Okay. Now let's talk about maintenance under secular law. Now, under Bharatiya Nagarik Suraksha Sanhita, which replaced CrPC, Code of Criminal Procedure, Bharatdand Prakriya Sanhita of 1973, after some 50 years, Bharatiya Nagarik Suraksha Sanhita came into picture. And this criminal procedure, this law, which is essentially about criminal procedure, provides law related to maintenance. Why so? Because it will provide speedy and effective remedy. Maintenance under Bharatiya Nagarik Suraksha Sanhita section 144 of the BNSS provides for maintenance to the wife and children and parents. And why a person will prefer to file a case under criminal law and not go under family law, the logic is very simple. The remedy under Bharatiya Nagarik Suraksha Sanhita is very quick, and it will be provided immediately and without proving anything. This Bharatiya Nagarik Suraksha Sanhita provides for maintenance as a let's say immediate relief. That you want maintenance, you are facing destitution, that I'll be thrown to the streets. You can immediately approach the magistrate and say, Ki, sir, I want maintenance. And the magistrate will immediately provide some maintenance, so that a person will not be thrown to the streets. See, civil matters take a lot of time. Determining actual amount of maintenance will require a lot of evidence to be considered. Husband की income कितनी है और कितना मिलना चाहिए, उसका assets कितने, उसकी liabilities कितनी है. A lot of factors will have to be considered before fixing final amount of maintenance that is given under personal laws, Hindu law, Muslim law. But under secular law in Bharatiya Nagarik Suraksha Sanhita, the maintenance is temporary and quick. And again, here the court will not have to look into the principle of parity. The magistrate will simply award maintenance which is appropriate to survive. So that this is a speedy remedy, a temporary remedy. If a maintenance is fixed under personal law, then this order of CrPC will not be there. So, or BNSS will not be applied. But nonetheless, this is a very quick and effective remedy. Similarly, under Protection of Women under Domestic Violence Act, the law is enacted in 2005. The complete name of the act is Protection of Women from Domestic Violence Act. Now, domestic violence looks like a criminal legislation, but effectively it is about remedy. A woman can seek 5 kinds of remedy under Domestic Violence Act, like protection order and custody order, and also maintenance order. A woman who has been subjected to domestic violence can approach the magistrate, to approach the court, and get something called maintenance order, in which the husband or any person for that matter who has subjected her to that domestic violence, be it father, brother, uncle, grandfather, anyone. Domestic violence, that is in that way is very broad. I was in a domestic, if a woman is in a domestic relationship with a man, or a woman for that matter, and she faces domestic violence, she can claim maintenance from the person who subjected her to that violence. She can claim maintenance if it's proved on the primary by the prima facie evidence. If it is proved that she was subjected to domestic violence, then the magistrate can immediately grant her maintenance order. It can also grant the custody order and compensation order, all those orders, protection order, all those remedies can also be given, but it also includes maintenance order. So the maintenance can be given to a woman who has been subjected to any kind of domestic violence. Then finally, another legislation is Maintenance and Welfare of Parents and Senior Citizen Act of 2007. In this act, there are few very important provisions. First is that an elderly person above 60 years of age, if they are incapable of maintaining themselves, they can seek maintenance from children or grandchildren. That is already there. But additionally, they have some more rights. They have rights like if their property is administered by someone, they have a right to claim maintenance from them. Or if they gifted property to someone after this enactment of act, on the promise that the person to whom the property is gifted will maintain them, or even on a supposition of that. See, more often than not, it happens that the elderly people, they gift their property to the children with an expectation that the children will maintain them and they will also take care of the property. And it often happens that the children, they take the property and simply leave the parents. So in those cases, the senior citizen or the parent, the elderly people, they have a right to cancel that gift. They can simply reclaim that property that they have given, saying, "You see, the promise was that I'm giving you this property and you will maintain me. So if you're not maintaining me, I'll take back the property." Similarly, any senior citizen who is childless, let's say, they don't have any children, no son, no daughter. See, this is very important. A daughter has an equal responsibility. A woman also have an equal responsibility to provide for children and parents. So if there is no son, there is no daughter, in that case, that elderly parent can claim maintenance from any person who would inherit that senior citizen's property. Even if they don't have any property, then also there is somebody here. Obviously, nobody is without any property. Suppose if they have 1 rupee, the question is who will inherit that 1 rupee? That person will have to provide maintenance to that senior citizen. Like if there is a nephew, if there is a niece, they will have to provide maintenance. But this obligation is not only on the children or the heirs, but this obligation is also on government. Now, the government is obligated to create old age homes. In every district, they will have to make a old age home and provide maintenance for the elderly people. That's an obligation of the state. They have to ensure that the elderly people are taken care of, and they have to simply upon an application by elderly person, or simply by the suo moto, or any person for that matter can approach the court of law or the government ki sir, this person is in need of, this is an elderly person, he is in need of help and protection. The government is obligated to provide for them. So the Maintenance of Welfare of Parents and Senior Citizen Act compels the government to make such policy which takes good care of our elderly people, who are the experienced, who are the most matured people of the society, whose guidance is very much required. So if a person is childless, or he has been abandoned, or is in need of care and protection, unfortunately you will see many cases in which the children, they shift to a foreign country and leave their parents on their own. And in those cases, it is very difficult to actually uh, make sure that the children are who are now foreign citizen or foreign residents, they are obligated to maintain the parents and like that. So that is why the government also has an obligation to make sure that the elderly are taken care of. So the maintenance under secular law is also there, and these secular law are applicable to everyone irrespective of the religion. No person can say ki my personal law does not allow this, so I will not maintain or I will not provide for the other party. Every person, throughout, every citizen, every person resident in India is obligated to provide maintenance under these secular laws. So these laws are very effective. Sometimes a person claims maintenance under multiple laws. There is multiplicity of litigation. So the courts have to take care. Suppose a petition comes to them for maintenance, and suppose the person who is getting the who is seeking maintenance is already getting maintenance under some other law. So this court, second court, in which the maintenance petition is again filed, they will have to keep into account what they are already getting. If what they are already getting is sufficient, then this new court, the second court, will deny maintenance to them. Or if they think some additional maintenance is required, they'll consider that, so that a person does not have to be the person who is paying the maintenance cannot be harassed. So the court decides maintenance or alimony, and it is based on very rational principle. More often than not, the parties themselves agree that how much maintenance or how much alimony has to be given. So this is very interesting. You will see this topic in great detail when you are in law school, but I have tried to give you basic information about it. I hope you got some idea. So keep learning. Thank you so much for being patient listeners. In the next class, we'll discuss the ideas or the laws related to adoption, which is again a very interesting and important topic. Thank you so much. I'll see you in the next class.